Good morning. This is call number 2020-35669 in the interest of Irving Jones. Please, all parties, raise your right hands to be sworn. You solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes, sir.
All right, ma'am, please state your name and your relationship to the child.
My name is Aisha Jones, and I'm his mother.
Sir, your name and your relationship to the child.
My name is Irvin Jones, and I'm his father.
And representing the mother.
Your Honor, my name is, I'm sorry, Your Honor.
Go ahead.
My name is Olaide Banks.
All right, and representing the father.
Honor, my name is Mac Pierre-Louis.
All right, and what are we doing today? Oh, I'm sorry, for the state.
Good morning, Your Honor. Angela Jeffries for the Office of the Attorney General.
All right, what are we doing today, Ms. Jeffries?
Yes, this is a motion for a new trial filed by the non-custodial parent. So I would defer to him as is his motion.
All right, counsel.
Yes, thank you, Judge. Your Honor, my client and I, we filed a motion for new trial to set aside a default judgment that was taken back on January 20th, 2021. If the court would permit, I'd like just a couple minutes to do an opening statement, and then I would call my first witness.
Okay, go ahead.
Okay, Your Honor, the evidence will show that the resulting default order that was obtained because my client never got notice of the Zoom information that the court provided back in December 2020. The Attorney General provided me just this morning with proof that Zoom information was sent to my client by mail. But my client will testify that he never received this information. And the notice that I was provided with this morning has not been filed with the court. The evidence will show that my client satisfies the Craddock v. Sunshine Bus Lines case law. Under Craddock v. Sunshine Bus Lines, Inc., which is under 133 Southwest 2D 124. If the respondent can establish the three Craddock methods, then the court has to set aside its default judgment. He has to show that him not being in court was not intentional, but it was accidental. He has to show that he has a meritorious defense. And he has to show that there's not going to be a delay or injury to the other side, to mom, Miss Jones. The evidence is going to show that my client can satisfy those three prongs, and that the resulting order was not only improperly obtained because it was not, the notice of Zoom wasn't properly given to him, but also because the resulting order was unjust. Just based on the numbers you'll see yourself in the order, where he's having to pay $1,100 a month in child support when he's making minimum wage, or a $65,000 judgment against him for back child support, when there's argument to be made, he's had the child as much as she has. We're going to be asking that this order be taken and that the parties be sent to mediation where they can try to work this thing out.
All right, Mr. Banks, you have a response?
Sorry, yes, Your Honor, I was on mute. Brief opening response. Yes, so we oppose the motion, and we oppose the motion. Number one, the Craddock factors cannot be met. First of all, the evidence will show that Mr. Jones was served properly. right? It will also show that he was callous and flippant regarding this court's time as well as other court proceedings, and he just blew them off. That was number one. Um, it will show also that he did not he can't make a meritorious defense. He had his opportunity to make his defense at that time. At this time, we're just kind of dragging it out. And we'll also be able to show that there would be harm to my client and the child because what we would be doing is sustaining a period of more than 4 years without our regular support. And so for these reasons, and the fact that this matter has gone through the absolute correct process, we'd ask the court to deny this motion for a new trial.
All right, the state.
Yes, Your Honor. The state's position is essentially that, in fact, Mr. Jones was properly served. He did, in fact, receive further notice of the setting with the Zoom information provided. Nothing came back to the state to show that that address was inaccurate or invalid. And so we believe that the default order was obtained in a just manner and that we followed the rules of the court in the Texas Family Code and obtaining our default. Any accusation that harm would not be here, I don't think is appropriate. But our position mainly, Your Honor, is that we did in fact serve Jones and we did give proper notice of the hearing.
It appears that he was served personally, and he never filed an answer. Counsel, Mr. Pierre Lewis, he never filed an answer.
That is correct, Judge. I was not his attorney at that time. He was representing himself. It would have been a no answer default.
Exactly.
However, he was served with notice to appear in person. Now, this was back in July 2020. In December, the court subsequently sent out a new order of hearing saying that he needs to appear on Zoom. That's the crux of our argument, that Mr. Jones never received that notice. The state's provided a tracking number that shows that further notice was mailed to his home, the 8010 Echinacea address, where it was apparently left there on December 9th, I believe, 2020. That's not in the court's file. I just got notice of that this morning. But my client's testimony is that he never got this letter. He would have been at Zoom if he knew to be there. And he only found out about this after the court had defaulted him by having a call with the Attorney General's office in the same day. And then he immediately hired me the very next day. And that's when I put Zoom on his phone. And that's why we started this whole process. So it's really a notice issue, one, but that aside, it's also a unjust judgment issue as well. You know, the law presumes that we're going to be imputing minimum wage on somebody when there's no evidence being presented. And from our understanding, almost $9,000 per month gross income allegation is being was just put on by testimony by Ms. Jones. I understand she's his wife. She's the wife who may have personal knowledge. However, I don't think it's just to have a default judgment support at almost $9,000 per month income when a person's job was literally killed off by COVID-19 because he's a photographer and a driver. So those are the two reasons mainly, Judge, where we're wanting a new trial. As far as the delay in the injury, we're willing to go to the mediation immediately. We've already submitted our documents to DRO to try to get to the table so we can start discussing this. And we don't need to keep dragging this thing out. That's not our intention. It's not to just delay. We want to get this case moved on. Side note, Judge, the parties have a divorce that's pending as well. So no matter what happened today, the parties are still in court. We would want to at least do some temporary orders over child support issues. If we could just go to mediation, but this underlying order just needs to be tossed, and that's our position.
Well, okay. He was served. He didn't file an answer. Your motion for new trial is denied. Whether they gave him a note, whether he received the notice on the UPS tracking device or not, doesn't make any difference. That they were doing that as a courtesy. But he didn't file an answer. He didn't do anything about it. So your motion is denied.
Okay, Your Honor, will you hear testimony from my client, or will that not change
Oh,
your mind?
glad to hear it. Go ahead.
Okay, I'll call my first witness. Mr. Jones, please state your full name for the judge.
Irvin Lamar Jones.
What's your relationship to the child in this case?
I'm his dad.
Where do you live?
In 8010 Kenosha, Baytown, Texas, 77521.
And you now know that you had court on January 20th, 2021, correct?
Yes, sir.
And
I didn't know we had it on Zoom, though.
okay, just answer my question. And the return of service on the court system says that you were served back in November 14, 2020 at the 8010 Echinacea address. But where did that notice, that service notice say you were to appear?
At the courthouse?
Okay, and that court is currently closed due to COVID, is that correct?
Yes, sir.
And from your understanding now, all hearings are to be on Zoom?
Yes, sir.
The Attorney General is saying that it sent you certified mail notice confirming the Zoom link, and it mailed you at 8010 Echinacea Drive on December 2nd. It was delivered on December 9th. I do see a tracking number that shows and confirms that that notice was sent to your home at 2:24 on December 9th. Did you receive this notice?
No, sir. No, sir. No, sirree.
And was there anything left at your door?
No, sir.
You signed for anything?
No, sir.
Okay. And you had not filed an answer in this case after you were initially served. Why was that? Were you unable to file an answer in this case?
No, sir. I couldn't find out. I didn't know how to. I didn't know how to do the courthouse for close.
When was the first time you learned that you were defaulted?
The day the 20th when I went the day that I called the attorney.
Okay, you hired me on the very next day on January
Yes.
21, 2021.
Yes, sir.
And is it your position that the default judgment should be tossed, should be taken down by the court basically because you never received proper notice via Zoom?
Yes, sir. I should get a chance to defend myself. I didn't get a chance. I didn't get no Zoom. I didn't know. I didn't even have Zoom on my phone. So how am I know to work Zoom? I didn't even have it on my phone.
Okay. Okay. Your next argument on the motion for new trial is insufficient evidence. The resulting order says that you are to pay child support of $11.73 per month. Is that correct?
That what it said. Yes, sir.
And it bases that on an allegation that your gross income per month is $8,666.67 per month.
Yes, I don't make that kind of money a month.
Just answer my question. Is that what the order says, that your gross?
Yes, sir.
Okay.
Yes, sir.
Do you make that kind of money each month?
No, sir.
What do you make each month?
At least about $2,500 a month.
Okay.
I got bills to pay too. Damn. Got out.
Okay. Just answer my question, please.
Yes, sir.
Now, I know that you weren't in court back on January 20th, but to your knowledge, other than your wife's testimony about your income, do you know if any other financial evidence was presented to the court to get at $8,066 a month?
No, sir.
What's your profession?
I'm a photographer and I drive limos.
And did COVID-19 affect your employment?
Yes, sir.
Well,
And
this is not a hearing for child support, sir. This is a hearing. This is a motion for new trial. Your client received a citation that said you have been sued. You may employ an attorney. If you or your attorney do not file a written answer with the district clerk who issued this citation by 10 a.m. on the Monday next following the expiration of 20 days after you were served this citation and petition, a default judgment may be taken against you. He ignored that. It's
I
in
didn't
there.
know about it, Your Honor.
It's very clearly in the citation with the precept. So motion's denied.
All right.
Anything
And
further?
I guess just one more question, Judge, for my client. So your position is that the court should just set aside the default judgment, correct?
Yes, sir.
Okay. That's why I have Judge pass a witness.
Any questions, Ms. Jeffries? Any questions,
Yes, Your
Mr.
Honor.
Banks?
I just have a quick question for Mr. Irvin that I would like to ask on the record, just a few.
Yes, sir. Yes, ma'am.
Mr. Jones, what is your current address?
8010 Econosa Drive, Baytown, Texas, 77521.
All right, and on December 9th, you still lived at that address, is that correct?
Yes, ma'am.
All right, and you said that you testified it was closed. Did you show up to court on the date that you got the notice for? Did you show up to court at any
I
point?
went to the court door, but there wasn't anybody in.
Okay, and so they
And
didn't.
then I didn't. No, sir. I'm not. No, ma'am. Sorry. No, ma'am. But I didn't have no Zoom on my phone. So I went to my lawyer house to get the Zoom. I didn't know. I really would have been there, ma'am, if I could have. If I would have known how to work the Zoom, I would have been showed up and defend myself.
So is it that you didn't know how to work the Zoom, or that you did not get notice of the Zoom?
I didn't get no notice of the Zoom, number one. But when I went to my lawyer office, he told me that I have to do it by Zoom. So he set the Zoom up on my phone. I didn't even know nothing about the Zoom, man.
Okay, no further questions for this witness, Your Honor.
Mr. Banks, anything further?
No questions, Your Honor.
All right, motion denied.
Your Honor, we ask you one question. If my client did show up to the courthouse on the day that he was served, then what you had earlier read regarding the citation does not address the
Mr.
issue.
Pierre Lewis, he did not file an answer in the period of time at all. In fact, it was 2 months or whatever afterwards. He had plenty of time to file an answer or hire you. He didn't do it. It's denied. This hearing is over.
Thank you, Judge.
You're
Thank you.
excused.
Thank you.